Welcome to Business SOS. This is Rich Sierra, President of the Florida Small Business Legal Center here in Boca Raton, Florida. This is episode 66 of Business SOS. We're inching one episode at a time to episode 100, which is my goal, and continue after that. But as a podcaster, you do episode 100. That's a big accomplishment, so I'm really excited about that as we continue providing information to business owners. If you're listening to us, you might be a business owner. That information will be helpful to you, especially facing the legal challenges that you are facing in your business journey. And I select topics that I think are relevant, they're topical, they're current, that I believe you can take something with you for listening to me this morning. And as I begin the show, if you want to reach me, you have any questions that you'd like me to address on the show, my email is rich@richsierra.com. Again, it's rich@richsierra.com. And you can send me any questions you might have you'd like me to address in the show. I won't mention your name. And if I do that, I'll send you a free copy of our book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. So let's get right into it. A few months ago, there's actually in March, there was a new regulation that came that was published by the U.S. Department of Labor, and that deal with employees a new independent contractor classification under the Fair Labor Standards Act, and this was revised in March 2024. So I did that topic around that time, and I want to address it again simply because I'm getting questions from many of my clients and prospective clients, and they say, I want to have an independent contractor agreement drafted and for my 1099 employees. And I said, well, tell me more about what this employer is going to do, what this person is going to do for you. Well, they're going to be working for me as a salesperson and work full time. They have to come to the office. I'm going to provide all the tools, but I'm going to pay them as a 1099. And I'm like, my answer to that is like, well, that's an employee. That's just not an independent contractor. So I want to revisit the topic again, and I want to talk about, what is the economic reality test? How does the Department of Labor looks at independent contractor, and what criteria they utilize to determine whether or not that person working for you would be classified as an employee or as an independent contractor? And this came right from the fact sheet 13. It's employer independent contractor classification under the Fair Labor Standards Act. And I'll have a link to that in my show notes. If anybody wants to look at it and download it, you're welcome to. It's very informative. And in fact, I'm going to be reading many portions of it just for your benefit if you don't have the time to review it or go and download it from the web. But what is important, if you have a takeaway here, is that the economic reality test, and I'm going to go over those elements in a second, is a very broad. And the idea is that, the Department of Labor does not want you to be paying employees as independent contractors when they, in essence, are employees. So you're not paying the proper overtime, you're not withholding wages, you're not paying payroll taxes, and there can be significant penalties by doing so. So, and if you have an accountant as well, your accountant should advise you that if these individuals are really employees, you're paying them as independent contractors, there could be penalties associated with that. So you need to be aware of that. Even if your accountant says, no, that's fine, it might not be fine because ultimately you're responsible for that. So I just want to make you aware that there's the classification now is broader than before, and what they use is what is called the economic reality test. And they go over 6 individual factors, and I'll read them to you, and I'll go over them individually for you. And one of them is opportunity for profit or loss depending on managerial skill. The second one is investments by the worker and the employer. 3 is the permanence of the work relationship. 4, nature and degree of control. 5, whether the work performed is integral to the employer's business. And last but not least, skill and initiative. So those are the 6 factors, but I also say that the goal of the economic reality test is to decide if the worker is economically dependent of the employer for work or instead in business for themselves. All factors are to be considered. No single factor determines a worker's status, and no one factor or combination of factors are more important than the other factors. Instead, the totality of the circumstances of the working relationship should be considered. So these factors, you have to look at them all together, necessarily one at a time. And they also go on to say in this report, if the economic realities show that the worker is economically dependent on the employers for work, then the employer is an employee. If the economic realities show that the worker is in business for themselves, then the worker is an independent contractor. Employment under the Fair Labor Standards Act is not determined by technical concepts or common law standards of control. It is broader than the common law standard often applied to determine employment status or under other federal laws. So it is important for you to understand, whether you have employees or whether you have independent contractors. And if you have individuals working for you that you're paying under a 1099, but the reality of the employees, you need to make corrections. You might have to make them employees, and you need to talk to your accountant, your attorney, how you can make that transition, but don't perpetuate a problem if you know that it's a problem. Okay, if you're paying them as 1099s, you know that they're employees, you need to make them some changes. My recommendation is talk to your CPA, your attorney, and see how that can be done. The consequences of not paying them correctly, let me go over that first, right at the very beginning. Say you have this independent contractor, you're paying him or her as a 1099 employee, you have an issue that you have a termination with this individual. That individual then applies for workers' compensation. You said, no, it's not qualified. He's an independent contractor. Then that individual goes to an employment attorney and explains the situation. And this has happened to some clients in the last few years. So it goes to an employment attorney that specializes on wage and hour issues and litigation and suing companies for unpaid wages or improper withholding for employees. That's their area of practice. Perhaps I should bring on here to talk about this at some point. It's an important topic. So what happens? This individual, disgruntled, independent contractor, goes to the attorney and says, "Listen, I got fired. I don't qualify for an employment because I'm an independent contractor." So the attorney's going to go through this analysis and say, "Well, tell me about the type of work you did," and it's going to ask the question, "Okay, so were you required to show up to work? Yes or no?" The answer is yes. In this case, will you get paid a specific hourly wage? How were you paid? By the project? Were you paid by the hour? I'm just using this as an example. Say the person said I was paid by the hour. Okay. And if you did not, where the employer provided all the tools, yes. Did you bring any of your equipment? No. And will you provide training to this work? Yes. How long? In that first analysis, just with just a few questions, the attorney most likely is going to determine that this individual was an employee. So then the analysis goes into, okay, how long did you work for this company? Said, okay, it was like 2 years. And you were paid as 1099 for the last 2 years. So yes. Did you work any overtime? Yes, sometimes I work, 5-6 hours a week of overtime, but they just pay me by the hour. Okay, so you have an unpaid wages overtime claim already being prepared, or being, kind of a potential overtime claim right there with that answer. And so were any taxes were withheld? No. Any payroll taxes withheld, paid? No. So most likely this attorney is going to take this person as a client based on an unpaid wages claim. It's going to be a potential overtime claim as well. And you receive a demand letter in some cases from this attorney telling you you owe this individual this amount of money for unpaid wages, and ask you to preserve all the books and records, all the payroll records, all the hours, and any type of timesheets that you have for this individual. Then you say, no, I'm not going to do anything. A lawsuit could be filed in federal court or state court, most likely it'll be federal court, under violation of the Fair Labor Standards Act for unpaid wages. And that's a very expensive lawsuit to defend. I'll tell you that based on experience that I've represented some clients in this type of litigation, and they're separate, and it's really a pro-employee type statute, federal statute. In some cases, when the employer does not have the records to reflect the hours worked, the timesheets, it is presumed that the employee's allegations are correct. So you have really, you're faced with a wage and hour type of lawsuit. You're in an uphill battle, and if you are facing that type of claim, if it's a demand letter or an actual lawsuit, my recommendation is call an attorney immediately to help you navigate and try to resolve that issue. Do not do this on your own. It is completely, you're over your head if you try to do that. You want to go ahead and get an attorney to respond to it and properly handle it. But at the same time, if you're in Florida, perhaps in federal court as well, that if you're a corporate entity, you need to have an attorney representing you anyway. So you'll have to hire an attorney regardless. So that's my recommendation. If you're facing something like that, you have to go ahead and hire an attorney as soon as possible. So let's go through the economic reality test factors. One more thing. In terms of penalties, you can be made paid back wages. You can be made paid penalties as well. And also in this particular statute, there's attorney's fees provision that are separate from whatever you pay the employee, and has to be approved by the court. So, and the reason it has to be approved by the court is because the court wants to make sure that the employee gets compensated properly for the wages that were not paid to that employee in the first place, but also then the court will approve attorney's fees to that law firm who successfully brought that claim against the employer for not paying the proper wages. So that's a separate, analysis altogether. But the point that I'm making here is that the exposure that you have as an employer for improperly classifying employees or individuals as independent contractors when they're employees is significant. And so don't take this lightly. If you have any questions, call your CPA, call your attorney, and they can basically walk you through this analysis to see if you need to make any changes. So let's go through this economic reality test fairly quickly. The opportunity for profit or loss depending on managerial skills. And what this factor, and I'm going to basically paraphrase and read some of the passages here just to give you an idea. This factor primarily looks at whether a worker can earn profits or suffer losses through their own independent efforts and decision-making. Relevant facts include whether the worker negotiates their pay, decides to accept or decline work, hires general workers, purchases material, equipment, engages efforts and expand a business, secure more work, such as marketing and advertising. So if this individual you're hiring to do work basically has his own business or her own business, okay, that person is not an employee. They basically, they have other clients. You're not the only client, and they solicit business. So that is one of the things that they're looking here in terms of analysis. And they give you two different examples here. An example, number one, is a worker for a landscaping company performs assignments only as decided by the company for its corporate clients. The worker does not independently choose assignments, ask for additional work from other clients, advertise landscaping service, or try to reduce costs. The worker regularly agrees to work additional hours to earn more money. In this example, the worker does not exercise managerial skill that affects the profit or loss. Rather, the earnings may change based on the work available and the willingness to work more. In this example, it states here in the report, because of this lack of managerial skill affecting the opportunity for profit or loss, this fact indicates employee status under the opportunity for profit or loss factor. So it's just an employee. The only way he can actually earn, or she can earn more, is by working more hours. It's not really a profit sharing arrangement. So in contrast, it says here, a worker provides landscaping services directly to corporate clients. The worker produces their own advertising, negotiates contract, decides which jobs to perform, when to perform them, and decides when and whether to hire helpers and assist the work. Common sense tells you it's a landscaping company. They have their own workers. They have their own clients. It's not an independent contractor. It's not an employee. Apologize. Another aspect to look in here is investments by the worker and the employer. What this factor looks is whether the worker makes an investment that are capital entrepreneurial in nature, investments by a worker that supports the growth of the business, including by increasing the number of clients, reducing costs, extending market reach, or increasing sales, weighs in factor of an independent contractor status. An example I can give you that is like a joint venture agreement or a partner in a company. A partner can be an employee, but in this particular case, the example they give you that the person is investing in the business is basically kind of a partner. That's considered an independent contractor. Now, it says a lack of such capital or entrepreneurial investment weighs in favor of employee status. And I'm not talking here about a profit sharing plan. That's that's more of a different conversation. This is strictly for the analysis of whether the individual working for you could be classified as an employee or independent contractor. And they give you some examples here. A graphic designer provides design services for a commercial design firm. The firm provides the software, a computer, office space, and all the equipment and supplies for the worker. The company invests in marketing, finding clients, and maintains a central office for which to manage services. The worker occasionally uses their own preferred drafting tool for certain jobs. In this scenario, the worker relatively minor investment in supplies is not capital in nature and does little to further a business beyond completing specific jobs. These facts indicate employee status under the investment factor. And they give the contrast in this particular category. Graphic designer occasionally completes special design projects for the same commercial design firm. The graphic designer purchases their own design, software, computer drafting tools, rent their own space. They also market their services individually to other clients. So that graphic designer that you hire to do your brochures, your website, your business cards, social media, they work with other clients. They're not an employee. Okay, that's pretty much common sense. This one is interesting. This is number 3, the degree of permanence of the work relationship. This factor primarily looks at the nature and length of the work relationship, whether it's sporadic or project-based with a fixed ending date or regularly occurring fixed period of work, whether the worker may make a business decision or take multiple different jobs indicate independent contractor status. A work that is continuous does not have fixed ending date or may have workers only work relationship indicate employee status. So if this employee only works for you regularly, doesn't have any other work, doesn't solicit other business, and is continuous in a regular schedule, that person is an employee, even if it's not, every single day. It could be in an assignment, but that's basically that's really more employee status. And they give a number of examples here. A cook that prepared meals for an entertainment venue continuously for several years. And, that person, the cook prepares meals decided by the venue, depending on the size, specific for the event. The cook only prepares food for the entertainment venue, which has regularly scheduled events each week. So the relationship between the cook and the venue is characterized by a high degree of permanence and exclusivity, as the cook does not cook for other venues. That's an employee. The fact indicates employee status under the permanence factor. And then they have another example on the same. Cook has prepared specialty meals occasionally for entertainment venue over the past 3 years. For certain events, the cook markets their meal preparation services to multiple venues and private individuals and turn down work for entertainment venue for any reason. That is a independent contractor. Nature and degree of control, that's number 4. This factor primarily looks at the level of control of the potential employer has over the permanent performance of the work and the economic aspects of the working relationship. Relevant facts include whether the potential employer controls hiring, firing, scheduling, prices, or pay rates, supervises the performance of the work, including via technological means, has the right to supervise or discipline workers, and takes actions that limit workers' ability to work for others. Where the potential employer maintains more control over these aspects of the work relationship, this factor weighs in favor of employee status. If you have control of their schedule, their hours, the time, the pay rate, they're an employee. And obviously the opposite is true. If you don't have no control, they can come in and go as they please, provide their own tools. They can turn down work when you're not available. That is an independent contractor. And they have 2 examples here. Registered nurse provides nursing for Alpha House. That's basically it's a fictitious house the name you're using. The nursing home sets work schedule, input from staff regarding their preferences, and determines staff assignments. Alpha House policies prohibit nurses from working from other nursing homes while employed with Alpha House to protect its residents. In addition, nursing staff are supervised by regular check-ins with managers, but nurses generally perform their work without direct supervision. While nurses at Alpha House work without close supervision and can express preferences for their schedule, Alpha House maintains control over when and where a nurse can work and whether a nurse can work for another nursing home. These facts indicate employee status under the control factor. Then the opposite is true in this case. Another registered nurse provides specialty movement therapy to residents at Beta House. The nurse maintains a website and is contacted by Beta to assist its residents. The nurse provides movement therapy for residents on a schedule agreed upon between the nurse and the residents without direction or supervision from Beta House. So it sets the price for services on the website. So if you see a theme here is that if this individual has his or her own business and they work with multiple clients, you contract this individual for specific assignments on a need basis, then very likely that's an independent contractor. And that's very easy to discern. The kind of the gray line here is when somebody is paid as an independent contractor, but they're required to come in every day to work. The extent to which the work is number 5. Extent to which the work performed is an integral part of the employer's business. This factor primarily looks at whether the work is critical, necessary, or central to the potential employer's principal business, which indicates employee status. Where the work is performed by the worker is not critical, necessary, or central to the potential employer's principal business. This indicates independent contractor status. So if that individual working for you as an independent contractor is somebody that is kind of a key, lack of a better word, employee, very likely that person is an employee. So whether it's a manager, whether it's somebody running the business, so you have to look at that as well. Number 6, skill and initiative. This factor primarily looks at whether the worker uses their own specialized skills together with business planning and effort to perform their work and support and grow a business. The fact that a worker does not use specialized skills, for example, the worker relies on the employer to provide training on the job, indicates the worker is an employee. Additionally, both employees and independent contractors can be skilled. So the fact that is skilled does not indicate one status or the other. The focus should be on whether the worker uses their skill in connection with the business initiative. If the worker does indicate independent contractor status, the worker does not indicates employee status. I'll give you an example of an accountant. Say you hire an in-house accountant to work only in your company, and that person is responsible just to, or a controller to run your book, to basically maintain your books and handle the company's finances, or keep track of the company's finances, if you will. But they work only for your company. That person is an employee. If you hire an accounting firm or an accountant to basically do the same thing, but they have multiple clients, they work outside the office, they work independently, that's an independent contractor. So obviously, if you have an employee, you're required to pay the minimum wage, at the very minimum, the federal minimum wage. If you have a state, Florida, it's a much higher minimum wage, but you're required to do that, and also pay overtime for any hours, 1.5 of the regular rate, for all hours work over 40 hours per week. Now, one more point I want to make about independent contractors, which is key, and I get this very, very often. I often get the question, hey, Rich, I'm paying this person. The person wants me to pay them 1099. So they don't want me to withhold taxes. The employee does not have a choice how they get paid. The employee cannot waive their requirements. So it doesn't matter if you know they're an employee, okay, you cannot make an agreement with that employee to pay them differently than is required by law. And I see many people making that mistake. It's not up to them to decide how they're going to get paid if they're going to be an employee of the company. So I just want to leave you with that caveat that please do not make those side deals because they just come back to haunt you at some point. And it makes it difficult for your accountant or for your attorney to help you if you're knowingly and willfully are making those side arrangements with the individual to be paid as an independent contractor when both of you know they're an employee. And in fact, they don't have the right to waive, neither do you, but it's your responsibility to make sure that they get paid, they get classified according to what they are doing for you. It's an employee or independent contractor. If the person has his own business or her own business, it's a different story, and they can sporadic work. But for full-time work that is continuous, please, make sure you classify them properly, regardless of what they ask you to do. So I'm going to leave you with that today. If you have any questions about this topic, please send me an email at rich@richsierra.com. If you would like to learn more about our legal services that we offer in our firm, my website is floridasmallbusinesslegalcenter.com. We're Facebook at FSB Legal. We're YouTube. If you want to watch the video of this podcast, we're youtube.com /@RichardSierra. If you have any questions, you'd like to give us a call, our number is 866-842-5202. Remember that Business SOS, a como legal mistakes, business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Remember, if you like the podcast, follow us in Apple Podcasts, Spotify, wherever you enjoy the shows. Give us a review. Share it with your friends. And until next week, this is Rich Sierra. Remember that my goal is to help you succeed.